Good afternoon. Welcome to the third session of Citibank BIAC Inter-University International Arbitration Contest 2021, organized by Bangladesh International Arbitration Center BIAC and supported by Citibank Limited. Bonik Barta is the media partner of this event, and this program is being live streamed in BIAC and Bonik Barta's online Facebook page. I'm Mahbuba Rahman Runa, General Manager of BIAC, and I have the honor to be with you throughout the session this evening. Dear all, BIAC is the first and only licensed and registered alternative dispute resolution institution facilitating resolution of domestic and international commercial disputes through arbitration and mediation in Bangladesh. BIAC started its operation since April 2011. BIAC has developed all the facilities required for systematic and comfortable arbitration and mediation proceedings. BIAC has its own arbitration and mediation rules. Apart from facilitating arbitration and mediation, BIAC also provides training courses on ADR, especially arbitration, mediation, and negotiation, to develop a pool of human resource in this field. Since inception, BIAC has been working hard to create awareness about ADR methods by conducting several outreach programs, seminars, workshops, dialogues, and webinars. In 2020, BIAC added a new initiative to its activities, which is Arbitration Contest for university-level students. Last year, we organized the first ever arbitration contest in the history of Bangladesh, which was completely conducted under digital platform due to COVID-19 with an aim of organizing this contest in the upcoming years. Keeping in mind, this year, we arranged a more broad-based international contest where universities from CIICA region are from Bangladesh. This year, 7 leading universities from Bangladesh and CIICA countries are taking part in this contest, which are last year's champion, University of Dhaka, Bangladesh, Damodaram Sanjeevaya National Law University, India, the London College of Legal Studies, LCLS South, Bangladesh, Bhuiya Academy, Bangladesh, Lahore University of Management Sciences, Pakistan, Independent University, Bangladesh, and Chittagong University, Bangladesh. In each round, every team will consist of 4 to 6 students from each university. Each team will be comprised of students with the role of coordinator, counsels, and witnesses for their respective sides. 60 minutes have been allocated for each team to present their cases. First session of the preliminary round of this contest was held on last Saturday, 6th November 2021, where London College of Legal Studies South won the session against Damodaram Sanjeevaya National Law University, India. In today's morning, we just finished our second session where team of Bhuiya Academy, Bangladesh, won against Lahore University of Management Sciences, Pakistan. Now we are in the last session of preliminary round where Chittagong University, Bangladesh is competing as claimant against the team of Independent University, Bangladesh as respondent. London College of Legal Studies South, Bangladesh, Bhuiya Academy, and the winner of this session will compete in the semi-final round along with the last year's champion, Dhaka University. Now, we will begin with the welcome remarks from the director of BIAC. I would like to invite Mr. M.A. Akmal Hossain Ajad, who has been with BIAC since September 2017 as director. Mr. Akmal Hossain Ajad is a former career bureaucrat and was Additional Secretary, Ministry of Agriculture, Government of Bangladesh. He also worked for a civil judiciary for a while before joining administration. Mr. Ajad studied law and public administration in the University of Dhaka and the University of Manchester, UK. He was trained on local level governance in India and on legislative drafting in Canada. Sir, please.
Thank you very much. Good afternoon. Mr. Chairman of this session, Mr. Rana Sajjad, Founder and President, Center for International Investment and Commercial Arbitration, Pakistan, also partner of Rana Ijaz and partners. Distinguished participants from the University of Chittagong and the Independent University of Bangladesh. Welcome to the third session of the preliminary round of the Citibank BIAC Inter-University International Arbitration Contest 2021. Our GM has spoken much about BIAC. I would just add a few more points as how we have been growing during this crisis period of COVID-19, which caused a catastrophe all around. Students were home quarantined with relatively less pressure of studies, which was a great time to enrich their knowledge and to add a certificate to their resume as to prepare them for professional advancement. BIAC tried to ensure equitable learning opportunities for all students while prioritizing their health and well-being through online learning. To make this home quarantine productive, BIAC organized its first online learning session for students in June 2020. BIAC has reacted to the current crisis of COVID-19 and the future new norms for the handling of dispute resolution by quickly converting cases originally slated to be in person to their virtual cost-effective system that allows cases to be arbitrated and mediated through the use of video technology. BIAC invited top lineup of expert speakers from country and abroad in a number of webinars who addressed the key issues on ADR of different sectors, particularly the adverse effect of COVID-19 on many jurisdictions, including Bangladesh. For the first time, BIAC organized a day-long training for 24 officers of the Legislative and Parliamentary Affairs Division under our Ministry of Law, Justice and Parliamentary Affairs, who are actively involved in vetting laws from all ministries and divisions. We have been working with Judicial Administration Training Institute by training judicial officers from all strata. We are working with the Ministry of Commerce and the Foreign Affairs as well regarding Bangladesh's prospect of signing host country agreement with the Permanent Court of Arbitration, The Hague, the Netherlands. We have worked with the Bangladesh Bank Committee to frame a guideline to banks as to how ADR can be used to settle non-performing loan issues. We have worked with the apex body of suggesting legal reforms, Bangladesh Law Commission, regarding amendment of Arbitration Act 2001. We held consultation sessions with university faculties and the lawyer community, briefed university students on their campuses on the usefulness of ADR. We advised University Grants Commission Bangladesh to add ADR in the syllabus of undergrad and postgrad students of law in all universities of Bangladesh. We have also advised Bangladesh Bar Council to include ADR in the syllabus of legal practitioners training programs to upscale their professionalism. With these few words, I would now request the session chairman to proceed with. Thank you very much.
May I now introduce our today's chairman of the session. We are extremely honored to have with us Mr. Rana Sajjad, who is the founder and president of the Center of International Investment and Commercial Arbitration, CIICA, Pakistan. He is partner of Rana Ijaz and Partners, Lahore. Mr. Sajjad is a practicing lawyer in Pakistan and the USA in areas including contracts, cross-border transactions, commercial litigation, and domestic and international arbitration. He is a fellow of the Chartered Institute of Arbitrators, UK, and an accredited mediator of the Singapore International Mediation Institute. Now it is time to start the contest, and I would like to hand over the floor to the chairman of the session to start and run the contest. Mr. Sajjad, floor is yours.
Thank you very much, Ms. Runa, for the kind words and the generous introduction. It's a pleasure and honor to be here. And I congratulate BIAC on organizing such an excellent mock arbitration contest, I think, which will certainly be very helpful for all the participants in developing their careers. But more about that later. I'll now put on my arbitrator hat and formally commence proceedings. Good afternoon, everybody. Thank you very much for being here. We're here to conduct the hearing in the matter of Stream Port Limited versus Chittagong Port Authority. And we will be hearing both from the claimants and the respondents. In terms of housekeeping, I'd propose that we have the counsel, the first counsel for each party, provide a breakdown of the time and how they would like to structure their arguments, how much time they would devote to opening arguments, examination in chief, redirect, cross-examination, and of course, closing submissions. Because of course, I'll be keeping time. I think both parties are aware that you have 60 minutes each and you cannot exceed that time limit. With that, I would invite counsel for the claimant to please introduce himself and his team and let us know the breakdown of the time for the proceedings. Thank you.
Honorable Arbitrator, am I audible? Greetings,
Yes.
Honorable Arbitrator. I am Arafat Ibnul Basha, and together with Ms. Shupona Rai, will be representing the Stream Port Limited, that is the claimant in today's case. We will be presenting two witnesses, witness one, Mr. Sabbir Ahmed, witness two, Akib Tahamid. We'll be reserving 10 minutes for the opening statement and 10 minutes for the closing, and the rest of the time will be invested for the examination and cross-examination of our witnesses and the opposing witnesses.
Thank you for that. May I request you to please start your opening submissions?
Honorable Arbitrator, the claimant, that is the Stream Port Limited, have brought this action to remedy the repeated failure of the respondent to fulfill their obligations under the bareboat agreement, which has been signed by both the parties. Throughout the existence of this contractual relationship between the parties, the respondent has shown sheer negligence and have not displayed any hint of due diligence in their conduct towards the claimant. All the irreparable losses and damages suffered by the claimant has only been due to their intention to fulfill their obligations towards the respondent with due care and while the respondent evaded their obligations. Since everyone present here is well acquainted with the facts of the cases, we will not dwell upon it unless the Honorable Arbitrator has any questions regarding that. Honorable Arbitrator, we will move on to the first argument on the claimant's side, which is the respondent's rejection of the claimant's request of plying chartered vessel through the coastal routes was a violation of the bareboat agreement itself. Honorable Arbitrator, the initial bareboat agreement in its box 19 places trading limits to the inland river routes of Bangladesh. But it also mentions that the vessels cannot trade outside the Bangladesh territorial waters. If this is read with the clause number 11 of rider clauses of the bareboat charter, the trade limitation extends to the territorial waters of Bangladesh. According to Article 3 of the United Nations Law of the Seas, 1982, the territorial water of every state extends to 12 nautical miles from the baseline, which brings the coastal route within the purview of this agreement. Honorable Arbitrator, we do agree that the respondent had the authority to deny our request. But according to the established practices of the maritime law, any such decision must identify and evaluate the financial risks which might be the consequence of their decision, as per Mandaraka Shepherd's Modern Maritime Law, volume number 2. Further, under a bareboat charter, if the vessel cannot trade due to some fault of the owner, the charterer has no liability whatsoever to pay for that period. In this case, the losses that have been incurred by the claimant have been the direct consequences of the respondent's rejection made without any consideration of the agreement in hand or its financial consequence to the claimant in the long run. In this connection, Honorable Arbitrator, we present our second agreement, which is the failure to respond to the respondent regarding the claimant's intention to return the two vessels, which we contend is a violation of the bareboat agreement. As per clause number 3.
Counsel, if I may jump in, I have a quick question. So you mentioned that the respondent didn't have any obligation to accept, grant your request, and you're relying on industry customs and practices. Is that correct?
Yeah, yes, Honorable Arbitrator. If
there is no law that you're relying on, can you cite some type of case law or industry practices, custom that you want to rely on to substantiate your argument?
Our arbitrator in the book called The Modern Maritime Law, Volume 2, which it is a compilation of the practices of the modern maritime laws. It has been said that while any decision that is being made by the owner, they shall keep in mind the consequence, especially the financial ones of their decisions. And it has also been quoted that any such decision might incur civil or even criminal liabilities. While we are not contending any criminal liabilities, but we are contending that they have a liability under this agreement itself. Because as we have stated, the agreement itself allows us to ply our vessels through the coastal routes under this enlarged limitation, since it has said that the territorial waters of Bangladesh, which we have claimed that the territorial waters of Bangladesh includes the coastal routes itself. Honorable
Thank you.
Arbitrator.
Please proceed.
Thank you. Honorable Arbitrator, as I was saying, as per clause number 3, the vessels can be delivered before the date indicated in box 14 with the charterer's consent. And the respondent has an additional obligation to take the delivery of the vessels under clause number 2. The claimant has the right to return any number of vessels by giving notices within the prescribed time and manner as stipulated in the bareboat agreement. And in this case, the return of the vessels was necessitated by the rejection of the respondent to allow the claimant to ply the vessels through the coastal routes. But, Honorable Arbitrator, let alone take the delivery of the vessels, the respondent did not even give a response, which is not only a violation of the legal obligation under this agreement, but also a breach of good faith. Thirdly, Honorable Arbitrator, we made a request to withdraw the performance guarantee, which based upon the incidents mentioned before by me in argument 1 and 2 were just and logical. Although we did agree to pay the performance guarantee in the presence of insurance coverage due to the circumstances caused by the respondent and in no fault of ours, the claimant, doing such would have placed us in great financial burden. Saying that it was a just request, the respondent could have at least considered the merits of our request. But once again, they were silent. They did not even bother to send us a response. Honorable Arbitrator, our last argument is due to...
Counsel, was the respondent obligated to respond to your request under the agreement? Is there any specific clause that obligates respondent to respond to your request, let alone grant it?
Honorable Arbitrator, no, there was no explicit term that allows them, that obligates them to respond to our request. But as we are contending that there is a general presumption of a covenant of good faith in every contractual relationship. This has been ensured, this has been affirmed by many different jurisdictions in USA, in Bangladesh, and in the Canada, which we will elaborate in a few minutes' time. And according to that implied covenant, under the obligation of good faith, they had to give us a response. Although we are not saying that they should have abided to our request, but they could have at least given us a response. Honorable Arbitrator, if you are satisfied, may I move on?
Yeah, thank you. Please proceed.
Honorable Arbitrator, due to all these omissions of the respondent, we were forced to terminate the agreement. As per clause number 20, the agreement can be terminated by serving a notice of 28 days in advance by either of the parties. The repeated failures of the respondent to facilitate our trade and subsequent failure to even respond to our valid request has led us to take such decision. We are well within our rights to terminate this agreement. Besides, Article 39 of the Contract Act 1872 allows a party to an agreement to put an end to that agreement if the other party does not perform his promise in its entirety. Furthermore, after putting an end to the contract, the aggrieved party is also entitled to bring action for damages for breach under Section 73. But unfortunately, the respondent has not responded even to the notice of termination. As such, the delivery of the vessels has not been carried out due to the evasion of the respondents, and the claimant is incurring losses in a daily basis due to the maintenance of the vessels. Honorable arbitrator, as I was saying before, there is a general presumption of implied covenant of good faith in every contractual relationship, be it national or international. The courts in different jurisdictions have confirmed this position. In USA, Kirk Lushell versus Paul Armstrong Company, AC Shaw versus Washoe County. In England, Hadley versus Baxendale. In Canada, Passin versus Haino. And in the subcontinent, the Privy Council in Mohammed Ishaq versus Emperor has stated that there is not only an implied covenant of good faith, but the breach of this implied covenant will allow the suffering party, the aggrieved party, to bring an action against the opposing party, and depending on the circumstances of the case, they can also sue for compensation, which we are doing in this instance.
Counsel, I'm interrupting, but you have about 40 seconds left.
Oh, okay. Thank you, Honorable Arbitrator. So we will be contending that the covenant of good faith has been violated in this case, and also that the respondent has violated this bareboat agreement, that the current agreement stays terminated, that they are liable to give us compensation. If Honorable Arbitrator do not have any further question, I would like to invite my co-counsel to examine our first witness.
Yes, please proceed.
Am I audible?
Yes, you are.
Thank you. Thank you, Arfat Ibnul Bashar. With the permission of the tribunal, I'd like to call upon our first witness.
Yes.
Much obliged. Please state your name and designation before the court.
This is Sabir Ahmed, Additional Managing Director of Claimant Limited.
So, Mr. Ahmed, did you make a bareboat charter agreement with the on 3rd October 2016 with the chairman of Chittagong Port Authority?
Yes, I, in course of representing the Claimant Limited as the Managing Director of the same, I came in an agreement with the chairman Chittagong Port Authority on the 3rd of October 2016.
Okay. Can you please inform the tribunal that what was the trading limit when you signed for the agreement?
In line with the wordings of Clause 11 of rider clauses, and the trading limit was between Chittagong Panon and the territorial waters of Bangladesh. Apart from that, Box 19 of the contract agreement and Clause 5 of the bareboat charter agreement refers to the same, that Chittagong Panon and the territorial waters of Bangladesh should be the trading limit of our business, of the contract.
Okay, so you wrote letters in the year of 2018 in subsequent dates on 26 July and 18 September. What was the purpose of those letters?
Is the letters intimated on the 26th July 2018 and 18th of September was backed by the purpose of claimant's intention to ply the chartered vessels for the coastal routes, and was to seek permission of the owners to ply the same.
Okay. So what problems did you face through the inland routes that you are asking for the coastal routes?
To answer the questions, I would like to say that the inland routes and the coastal routes, there was a primary consideration of the profitability of the business. Primarily, it appeared to be necessary to ply the vessels through the coastal areas for augmenting profits and benefits of our business, which is not possible using the inland routes.
So what sort of benefits you can get through the coastal routes that you are so confident that you can get more profit or benefits from the coastal routes?
There are a set of benefits during that. Firstly, lower cost. Lower cost is a factor of primary consideration in terms of exploring into the source or amount of the benefit. And secondly, connecting the seaports. Connecting the seaports would be very convenient in that case. And thirdly, the model shift to coastal shipping helps reduce time and cost in operating business much more than in inland routes.
But the respondent didn't consent the same because they claimed that the payment is due, so they are not giving the consent same to the coastal road. Do you agree with that, that the payment is due?
No, of course, I stand in disagreement with the particular piece of claim. The respondent just made no consent to a letter of request without making any ground for the same. I agree that they did not consent, and I disagree that their making no consent was made stamped on the ground of due payment, as they did not make it a good ground for their rejection. So if payment of due, if the payment is due, there is option for title to interest for the same, according to the clause number 10 of the Bareboat Charter. So delay in payment should be followed by interest, as there is option for entitlement to the interest, not by any rejection to the letter of request. So I just would like to say that any delay in payment of hire according to the clause 10 of the Bareboat Charter, Bareboat Agreement would entitle the owners to an interest at the rate per annum according to the current market rate in the country wherein the principal place of business of the owner stands or prevails. So they could have taken resort to the option of the interest, not making any rejection to our letter of request. So I disagree with that.
Okay. So on 16 July 2018, you sent a letter to the respondent requesting to return 2 vessels among the 3 vessels. What was the reason for returning 2 vessels to the authority after 2 years of the agreement?
There were a set of reasons or purpose to stamp the letter on 16th of July 2018, bearing our intention to return 2 vessels and retain 1. The business has already gone through or incurred severe losses due to the non-cooperation of the owners of the vessels, as demonstrated by the owners not consenting to grant any permission to apply the vessels through the coastal routes. The owners' non-cooperation led our business to incur losses and made the potential for losses to augment or increase in future. So to avoid the inevitable potential of future losses, we decided to return 2 vessels and keep one vessel for our operating business, for operating purpose for business.
Mr. Ahmed, you mentioned about the financial losses. Can you elaborate about the losses you are facing through the 2 vessels that you wanted to return to the authority?
As we have already said that there is the failure incurred by the financial losses to the company as per the agreement. The claimant or the charterer for the Bareboat Charter are to pay the sum of 1,50,000 taka, including that party, for keeping the vessels. The default of the respondent to make responses to our intention to return the vessels has made us liable to pay the amount for keeping that, which we are not supposed to be liable to pay if we could return them.
So what was the response from the respondent about this issue?
To sum up, no responses were received from the respondent to the letter of request of work for this issue.
Did this failure incur any kind of losses to your company?
Of course, I have already said that there is a clause of paying 1,50,000 taka for keeping the vessels, and we could not return them. And moreover, they did not make any consent to our letter of request to fly the vessels into the coastal route, and their cooperation was not sufficient. At least it can be said that they were not so much cooperative to the smooth functioning of our businesses, which they were supposed to. So the losses are irreparable and the losses are severe.
Did the respondent knows that the failure of their response incurred that much of loss to your company? Are they informed about that, about your loss?
And of course, the repetitive actions of sending the letters of request to the claim from the claimants for the cooperation of the owners of the respondent, and having the same being back with no response is sufficient to intimate the respondent that we are going through severe financial losses.
So after all these incidents, you wanted to terminate the contract. What was the response from the respondent when you sent the letter of termination of the contract? How they respond?
No responses. No responses were placed and received by the respondent to the letter of request for termination. Moreover, we sent a reminder on the 16th of April 2019, a final notice on 19th of April 2019. Both of the reminder and the final notice remained unanswered by the respondent. So no responses were placed or intimated by the respondent in this respect.
Thank you, Mr. Sabir Ahmed. No more question, Honorable Arbitrator.
Welcome.
Your next witness. Are you going to be doing the examination, Chief, or your co-counsel will do it? Ms. Roy?
No, Honorable Arbitrator, I will.
Okay,
Chief,
please proceed.
All right, please. With the permission of the tribunal, I'd like to call upon our second counsel. Okay. Much obliged. Please state your name and designation before the court.
My name is Akib Tahmid and I am a maritime expert.
You must have heard about the bareboat charter agreement.
Yes, I have heard about it. I have gone through it. Yes.
So according to the agreement, the claimant requested for plying charter vessel through the coastal, inland routes, according to the charter. But later they requested for the coastal routes. What was the necessity for the claimant from the claimant side to change the route from inland routes to coastal routes?
Thank you very much for the question. Actually, the types of business the claimants were involved in required their business to be conducted in the coastal routes because the coastal routes had far great opportunities compared to the inland river routes. It is because of several factors. There are some certain trade limitations in inland river routes of Bangladesh which are relaxed in coastal routes.
Okay. Do you believe that the request for plying charter vessel through the coastal route may cause any benefit to the claimant?
Yes, if the claimant were granted permission to ply their chartered vessels through the coastal routes, definitely they would gain financial benefit. Otherwise, they would incur financial losses because if you look at the government policies, you would see that the inland river routes policies regarding trading are far stricter compared to the coastal routes where the policies are a bit relaxed. So for traders, obviously it is far more convenient to conduct their business, to conduct their trading in coastal routes. So yeah, I think the claimant would be benefited if they can ply their vessels and do their trading in the coastal routes.
Can you elaborate before the tribunal that what type of opportunities the claimant can enjoy through the coastal routes?
The coastal routes are vast. The opportunities are vast in there. Yes, as we know that there's 12 nautical miles of territorial waters which the claimant can enjoy to do their trading. Yes, and the policies. There's a law, Inland Shipping Ordinance 1990, which has some strict policies which makes the traders to conduct their business in the inland river routes far more difficult compared to the coastal routes. So yeah, if the claimant can conduct their business in the coastal routes, they would have incurred benefit and they wouldn't have suffered losses which they have suffered right now.
Okay. But the respondent rejected the request on some grounds. Do you believe that the rejection from the respondent can make huge financial loss to the claimant?
Yes, I believe that the rejection has incurred severe financial losses for the claimant.
Okay. So after the rejection from the respondent, the claimant again requested to return 2 vessels as they were facing huge losses within the prescribed time. What was the reason? What will be the reason for returning 2 vessels to the authority?
Actually, they were conducting their business in inland river routes of Bangladesh. And for that very purpose, and for the structure, if you consider the structure of the business, only 1 vessel would have been sufficient to conduct the business in inland river routes. They had to give chartered fee for 3 vessels, where 2 have them remained unused. As I have said, there's lack of opportunities to conduct their business in inland river routes. Only 1 vessel would have been sufficient for them. Because in proportion to the chartered fee they were giving for 3 vessels, they were not getting enough profits. But if they got the chance to ply 1 vessel in the inland river routes, they might have gained some financial benefit, which was actually possible. But actually, to conduct business in inland river routes, 3 vessels is not a necessity. Only 1 vessel would have been enough. And there's also a maintenance cost involved in here. So considering all this, I think the rejection of taking back 2 vessels incurred severe losses for the claimant.
Okay. But the respondent failed to perform their part and claimant faced huge financial loss. So as an expert, as a maritime expert, do you think the respondent is liable for the loss from the side of claimant?
Yes, I think the respondent is liable for the loss. It is because I've gone through the bareboat chartered agreement, and I found that there's a clause, clause 22, which empowers both the side to alter, amend, add, delete any provisions for smooth functioning of their business. So in this case, the claimant had no opportunity to function their business smoothly. They were incurring losses. They had to give notices to the respondent that we are incurring losses. We wish to gain access to the coastal routes. We will, and if you do not give the access to give us access to the coastal routes, take back 2 vessels. We can we can conduct our business with 1 vessel. All of it were denied. And I think for that very reason, respondents are liable. They didn't comply with the request of the claimant.
Okay. After all those incidents, the claimant requested to the authority to withdraw the performance guarantee from the contract. As a maritime expert, is it a lawful request from the side of claimant to ask to withdraw the clause?
Yes, at first they agreed upon to give both the performance guarantee also insurance coverage. But considering all this, since the claimant were at loss from the very beginning in several factors, and the non-compliance by the respondent, I think if the claimant gives both the performance guarantee as well as insurance coverage, they would have severe financial burden, and also they would incur severe financial loss. And as we all know that insurance coverages are enough as a sole guarantee. Yes, from the respondent sides, this could be agreed upon, but they denied that request as well. So I think, only the only the insurance coverage is enough for that very purpose.
Okay. The repeated failure from the respondent forced the claimant to terminate the contract. Do you agree the termination of the contract from the claimant side is necessary?
Since the claimant is incurring huge losses, I think the contract should be terminated. Otherwise, the claimant would have kept incurring more and more losses. And as we all know that in business, we need to make profit. They are not making any profit, rather they are incurring losses. So yeah, the contract should be terminated as soon as possible.
Thank you so much, Mr. Abid Tamid. No more question, Honorable Arbitrator.
Thank you, counsel. I'd like to invite the respondent to give their, I understand, opening submissions first, and then they will cross-examine? How do you want to do it? But before that, of course, please respond and introduce your team and the breakdown of the entire proceedings that you would prefer. Respondents Council.
Good evening, Mr. Honor Arbitrator. So, may it please the arbitrator, Lordship, this is the representative Sanjid Islam Kia on the behalf of respondent appearing in the matter of spatial performance and breach of contract, providing an outline of the submission and seeking permission from the arbitrator to present a claim.
Yeah, please proceed.
Being the first counsel, Nazrana will be dealing with the issues number 1 and issues number 4, which will be regarding as the respondent rejection of the claimant's request of flying contracted vessels through coastal routes was in contravention of the bareboat agreement and resulted in loss for the claimant. And another argument number 4, that is respondent was not obliged to answer the request of the claimant for termination of contract. And the second counsel, Humaira, will dealing with issue number 3 and 4, which dealing with the argument number 2 is it was not a failure on behalf of the respondent to respond to the claimant's intention to return to vessels after the stipulated time was over. And the third argument of the respondent was not obliged to respond to the withdrawal of the clause regarding performance guarantee. The third counsel will be dealing with the witness statement and the cross-examination, which will be leading by Nuhan. So here I rest my statement.
So counsel, are these your opening submissions? Or you will start your opening submissions now?
Sir, I will start my arguments.
Okay, please go ahead.
Good afternoon. May it please the tribunal. My name is Nazrana Khan and I'm representing my client as a senior counsel. I'll be presenting arguments 1 and 4, and it may take 20 minutes of the time. May I proceed, Mr. Arbitrator?
So counsel, you will spend 20 minutes on your opening submissions, and how much time for your closing submissions and for the examination, chief cross-examination? I don't think I got that information.
Mr. Arbitrator, it may take 20 minutes, but exactly not 20 minutes. I will take it as low as I can. So honorable counsel from the claimants claimed that the respondent's rejection of the claimant's request of flying chartered vessels through coastal routes was in contravention of the bareboat agreement and resulted in loss for the claimant. First of all, I would like to mention that their due is not cleared from 3rd February 2017 after the trial months of 120 days. Due is Bangladesh Taka 80,700,000 including VAT. According to clause 11, they should be paid the due after the 120 days. Secondly, they gave notice after the expiration date of giving notice, which is 30 days after the trial months, according to clause 19. And third, they didn't respond to my client's notice of pay the due payment. The parties had entered into a bareboat chartered agreement dated 3rd October 2016 pursuant to an invitation for tenders from respondent for bareboat charter of 3 CPA inland container vessels, namely MV Panel Express, MV Panel Success, and MV Panel Vision, Respondent accepted tender by the claimant or charters for the bareboat charter at the sum of Bangladesh Taka 1,50,000, including VAT per day. According to bareboat charter agreement, 120 days free time from the date of work order were given to the claimant that if they find any issue regarding the boats, they can return them. After 17 months and 23 days, claimant sent a letter request to change the route of the vessel at 26th July 2018, whereas they didn't pay a penny to the respondent after the free trial time, and they sent the notice even after the notice time expired. When respondent sent notice to the claimant saying to clear the due payment, the claimant didn't respond to the notice at all. And argument 4 says, respondent was not obliged to answer the request to the claimant for termination of contract. Clause, according to the clause 20.
Counsel, so I think you have a two-pronged argument here. On the one hand, you're saying that they sent the notice late. It was after the deadline had passed. And they're also saying that they had not made the full payment. So my question is, had they made the full payment, would you have accepted their request?
Much obliged, Mr. Arbitrator. If they paid the full payment in time, and then we will just respond to the notice. But the notice is not applicable because according to the clause 20, according to clause to box 20, 19, the trading limits not applicable for trading outside Bangladesh territorial waters, which includes that the coast. They noticed they requested to have to change the routes to the coastal routes, but they didn't mention any portal areas, which it is very confusing, and we cannot have that. We can't accept the request to that coastal area because their coastal area can be very dangerous for the vessels, because and the vessels we own, the tender offer has the agreement that the vessels is inland container, and the claimant, if the claimant uses the vessels to the coastal route, and wherever they want to go around and with the vessels, the natural calamities can occur and the vessels can be destroyed and that will be destruction, that will be unprofitable for our company. That is why we will not accept their request, but and that is why we will not accept the request.
There was a reference to customs and industry practices during the course of the claimant submissions. And I think what they were trying to imply was that you don't have to follow the letter of the contract or agreement very strictly. My question to you is that based on your company's experience, are exceptions ever made in terms of the deadline for sending a notice, receiving a notice, responding to a request, or they're strictly followed and there are no exceptions when it comes to that?
So there are no exceptions because it was a tender offer. It was not a negotiable agreement. It was a tender offer, and they came to us, they took the offer, they signed the agreement, and that was binding, that the vessels cannot be applicable in the coastal areas, in the outside territories, and that is why we will not accept any exceptionals. We follow our rules strictly.
Thank you. Please proceed.
Thank you, Mr. Arbitrator. My second argument is argument number 4. Clause 22 says that the agreement may be terminated by either party with 28 days advance notice, which does not support the other party. According to clause 20, there is no need to wait for the respondent's response, as the contract will be cancelled after the after a certain period of time. But if someone wants to breach, he can be sued. Compensation is claimed for not being able to respond in a timely manner to the claimant, but the common law system without harm will not receive any compensation. We didn't respond to their notice because we didn't have any notice at all, because there we didn't have any proper conversation service didn't happen, and that is why we didn't accept any kind of notice they sent, and they wanted to terminate the contract because of they could not continue their vessels, and they couldn't profit at all. But it is not our concern that they have profit they have not, but it is a contract, and contract will be terminated after a certain period time. According to the agreement, the contract will be terminated after 5 years, and in this time, if they want to break the contract, we can sue them, and it is legally binded that they cannot break the agreement, and they have to follow the rules, they have to follow the agreement which they knowingly signed. And we didn't want to sue them because if we sue them, they are well-known company and we are well-known company. We didn't want to name both of the name bad impression, and we gave them time to pay their due and fulfill the payment, but they didn't reply to our notice, and that is why they didn't they didn't reply to our notices. And that's all, my Mr. Arbitrator. If there is no question, the case can be raised. My junior counsel will proceed the rest of my case arguments.
So you
Thank
concluded the opening submissions, or is your co-counsel going to continue with opening submissions? Are your opening submissions done?
No, sir, my co-counsel will do the rest. Thank you.
Okay, sure. Thank you.
Good afternoon. Am I audible?
Yes.
Now I will proceed to the argument number 2 and 3. Good afternoon. May it please the tribunal. My name is Kazi Hamara. I am representing my client as a junior counsel. I'll be presenting second and third arguments. May I proceed, Mr. Arbitrator?
Yes.
In argument 2, it was not a failure on behalf of the respondent to respond to the claimant's intention to return 2 vessels after the stipulated time was over. The claimant claimed that my client failed to respond by the respondent regarding the claimant's intention to return 2 vessels in a contravention of their obligation. According to the argument, this says the claimant by letter dated 16 July 2018 intimated my client regarding its intention to return 2 vessels and retain 1 for obtaining purpose. Since it became highly unprofitable to operate all 3, but there was no response from my client's end, so Honorable Chairman, I think we do not need to define any other point except the one that is, according to the contract agreement of bareboat charter of 3 CPA inland container vessels in clause, there is clearly mentioned 120 days of free trial time from the date of work order. No charter hire to be paid during 120 days period. Mentioned in 120 days free trial time period. This is given for the necessary preparation and promotion of business. After that, they had to pay and continue the contract. But the contract was made on 3rd October 2016. And after the trial period, they should have informed my client about the problem that they wanted to return 2 vessels. But after almost 18 months of contract on 16 July 2018, they're claiming that they have sent notice, which is really invalid. They did not deposit any money either. So it is quite obvious that there is no need for my client to give them a response. And most importantly, my client got no notice from them. Please ask them if they send the notice correctly or not. If my client got the notice, though he would not respond because the trial period was over. And claimant mentioned again and again the expiry date is on 2nd October 2021, but it is the expiry date of the contract, but not the trial period. They're supposed to start depositing the money, start their 1.5 lakh taka with interest. They were even supposed to pay an amount of 30 days advance, which is taka 45 lakhs, including the VAT, which is mentioned in the box 21. We didn't get the money too. So we should get the money. We are giving that a counter claim. Again, in argument 3, respondent was not obliged to respond to withdrawal of the clause regarding performance guarantee. Although we did not respond to the letters upon receipt as the claim, this may be considered as an unprofessional conduct at maximum, but it was not an obligation for us to respond according to the bareboat charters contract agreement. The letters were sent after both parties agreed and executed the contract. According to box 20, the contract can only be terminated in case of war and national emergency. So the issue claimant is raising is that they want to terminate the contract because we did not respond to acceptable arbitration. Want to terminate the contract because we did not respond. That is not acceptable for arbitration, and also this point there is no way of amicable settlement. That was all from my side, Mr. Arbitrator.
Thank you. You have any further opening submissions, or have those been concluded now?
We have our witness.
So are you going to present your witnesses first? Or are you going to cross-examine?
My third speaker will represent the witness.
You'll do the direct first. Okay, please go ahead.
Nuhan, this is your turn.
Yes, sir, may I? So here I am to the check witnesses statement in respondent side. So I would like to call Rapsan. Mr. Rapsan, please respond your state.
This is Nisar Ahmed, designation chairman of Chittagong Port Authority.
So, Mr. Nisar Ahmed, what is your relationship with the company? May I audible? Mr. Nisar Ahmed. So what exactly happened the time of contract? You can see.
You experiencing technical issues?
Mr.
Our
Arbitrator, our witness has facing some technical issues. So I think Mr. Nuhan, you will go for the cross-examination.
Do you have another witness? Perhaps you can do the direct for the other witness while the technical issue is resolved. Is that possible?
Sir, Rafsan will be going for the two witnesses, playing the two witnesses role.
Okay, you can proceed with the cross-examination then. Counsel, what are we waiting for?
Sorry. So I want to cross-examine. So where the first statement who are saying, please respond to your present.
Counsel, I see the claimant's witness. Are you going to start now? Or
Yes.
shall I pick?
Yes, Mr. Arbitrator.
Yes, sir.
This is Mr. Witness, and I am Mr. Sal. I'm Sabri Ahmed, the Additional Managing Director of the Port Limited Company, and I am here to be process from my end.
So you are saying that you have not received any response from the company?
Yes, of course.
Yes, but we didn't find any documents regarding this, and in this modernized. So why you don't get didn't get sending a email?
The notice has been sent. The notice has been sent, and the notice has been sent with the due course of the operation. the notice has been sent, and it has been said in the fact sheet that I would like to mention. And mention that you can take notice of the date, the notice which was sent on 19th of April 2019, and which is received by the office of the respondent on 22nd April of 2019. Have you noticed it? The notice has been sent, and as well the notice has been received by the respondent. But still, the respondent or you are claiming that the notice has not been properly sent to you, which has already been received by the respondent.
So witnesses, so you are saying that most valuable benefit you can acquire for this permission for coastal roads. So right. So what cannot you see the box number 19? So box number 19 clearly said the outside of Bangladesh territory waters and trade is not permitted.
The box number 19 does not clearly state any prohibition for the same. Rather than you can take notice of the clause 22, which states that which has given primal consideration to the smooth functioning of the business of the charterer. It says that the company and the charterer and the owners both are on an agreement to amendment or addendum for the purpose, for the sake of the smooth functioning of the business. But that particular clause has not been paid by the claimant, by the respondent.
So you also said that wanting to return vessels after 2 years. So why are you coming after so long, and what are the fines after have kept vessels for a long time? So why you keep such a long time?
It is not saying in the agreement that keeping for the vessels for a long time and wanting or intimation to give intimation to the owners for returning the vessels are prohibited. And moreover, the reasons of returning the two vessels have arisen due to the non-cooperation of the owners. If the non-cooperation was not present from the side of the owners, we were not obliged to. We are not in an obligation or we did not have the obligation to return the vessels. We could keep them if the cooperation from the claimant or from the owners was sufficient in this respect. And moreover, there was no responses to the notices, to the request, to the letter of request from the owners. So that made us left to make this decision.
So you should know that such a fine you have given to the keep vessels so long. So what would be your statement in regarding this?
Of course, we are ready to make payment for this. We have not denied that, and we have already said that the payment is due. If the payment is due, there has been kept an option for the title of interest. But you have not said, you have not made any notice for your claim to the title of interest. If the payment is due, if the payment has been delayed, so we are ready to make the interest for the same. We have not denied that fact. But while making any ground for the same, we have made rejection to our letter of request. We have not made any responses to our notices or final remainder or reminders, whatever be paid in the form of notice.
So, Mr. Witnesses, I have last question for you.
Yes,
did they pay an advance while signing the contract?
Did they pay? Yes. No. There was no provision to make.
Did they pay any advance while signing the contract?
I would like to know from you.
So then,
provision you are making.
They don't get. So they don't give the
120 days. 120 days was given for the promotion of business, and afterwards, soon after the levy of the 120 days, which was given for the promotion of business. Yes, please.
I want to know, did your client give the payment after the signing, before the signing in contract,
Payment
which
could
is
not.
the call of advance?
It is a conventional rule that it is a conventional rule that payments are not given in advance to the contract. If the contract is made 100%
But why you did?
then the payment will be levied, and it's been made in an agreement.
So
it's a matter of surprise that you are just making your queries going out of your agreement.
it didn't send the advance, but why after 2 years you send the notice for the what happened in this such a long time? What would be your statement in regarding this?
My statement regarding regarding your question that reading with clause 12 of the bareboat agreement and clause 19 of the writing clause, the same the clauses gives the title to us to write to deliver the vessel with intimation of preliminary notice by the charter of owners of 30 running days and of definite notice of 14 days, and we have made our application or compliance to that clause. That is my statement.
So, okay, thank you, the witnesses. So I beg to coordinator and please proceed your move.
Thank you.
Mr. Arbitrator, I am the first witness from the respondent team and I have fixed maintenance issues. We can proceed if you allow.
Mr. Arafat, I wouldn't like to disrupt the proceedings. I think let's just finish the cross-examination of the claimant's witnesses first. Then we can have a direct of the respondent's witnesses. So, Mr. Nohan, please continue with the cross-examination if you're the one who's going to do the cross-examination of the next witness.
Sir, I'm done. Sir, I'm done the cross-examination.
That's it. Your cross-examination is complete?
Yes, sir. Still.
Okay. Claimant's counsel, would you like to redirect?
Honorable Arbitrator, are you asking for the cross?
No. Would you like to do your redirect examination? Do you have any questions after the cross-examination, or you don't have any questions?
Okay. First of all, the question from the respondent that why we asked for 2 years after the agreement. We wanted to clear that the problems we are facing after 2 years, that's why we wanted to inform the respondent that that the problems we are facing now.
Counsel, this is not the time for you to clarify that the purpose is redirect. Would you like to ask your witness any questions to clarify any things that you think are a bit confusing?
No,
Would you like to?
No.
Okay, thank you. Counsel respondent, you said the cross-examination is complete. Is that correct?
Yes, Mr. Arbitrator.
So you can now proceed with presenting your witness and you can do your direct examination of your. How many witnesses do you have?
Sir, I want to the cross-examine of my witnesses. May I?
Direct examination, yes. Not cross-examination, yes.
Yes.
Okay, please proceed.
So Mr. Nisar Ahmed here.
Yes, you're audible.
So what is your relationship with the company?
I am a personal lawyer to the company.
Okay. So what exactly happened in the time of contract?
On 3rd October 2016, a bareboat charter agreement was made between the chairman, Chittagong Company Port Authority, and its content.
So did anything mention about the free trial of the board?
Yes, it was mentioned that 120 days free time from the date of the work order. No charter hires to be paid during these 120 days. This is given for the necessary preparations and promotion of business. After the charter hire to be paid as per the clause 10 of bareboat charter agreement between CTA and charterer for the container vessels playing in the inland route of Bangladesh.
Mr. Arafat, can you turn on your video or it's not possible? Thank you.
So Mr. Ahmed, I have last question for you. So was there any suggestion of a free boat in trial?
Could you rephrase the question, please?
What was there any suggestion of the free boat trial?
The charter did not pay anything after the free trial period and even not informed anything in those 100 days. After 2 years later, in 2018, they are claiming that they gave us a notice, which is invalid. So we sent them a notice after 120 days, but the charter did not respond.
So I want to call the witnesses number 2, which you were presenting this statement number evidence to. Yeah, Mr. Nisar Ahmed. You playing a role in the second?
Yes.
Second. Okay. So Mr. Ahmed, is the party pay advance before the before enter into the contract? If the party pay any advance before enter into the contract?
Yes, they did.
Okay. So what were the conditions from your side in this agreement?
The conditions were trading limit, Chittagong to Panon Island container terminal and container terminal and the ports connected to inland river routes of Bangladesh, and definitely not applicable for trading outside the Bangladesh territorial waters. And charter hire money payable 30 days advance, taka 45 lakhs only, including VAT.
Okay, so thank you, Mr. Nisar Ahmed. I'm done in examine, so I beg to coordinator and please proceed your move.
So you have no more witnesses?
So Mr. Arbitrator, he is playing role in 2 witnesses.
No, are you done with your examination, Chief? Do you have any more witnesses?
Yes, sir.
You have another witness?
Mr. Arbitrator, he playing 2 roles.
Okay, go ahead.
I'm done. I'm done, and all questions are asking him.
Claimant's counsel, please proceed with your cross-examination.
Thank you, Honorable Arbitrator. Under the bareboat agreement, clause 4 mentioned about the free time of 120 days. Mr. Nasir Ahmed, under the bareboat agreement, clause 4 mentioned about the free time of 120 days. Can you can you tell the tribunal what was the purpose? What is the purpose for 120 days under the charter?
Counsel, could you rephrase one more time? Beg your pardon.
Okay, under the bareboat agreement, there in clause 4 there is a point that the free time of 120 days. What is the purpose of the free time of 120 days?
I have said this earlier to the third lawyer of the respondent that the necessity of the 120 days period was for preparations and promotions of the business.
Okay, so there is an argument that the claimant is requesting to return vessels after 2 years. Why they are requesting to return the vessels after 2 years? So there is no point in the free time 120 days that that no request or complaint cannot be made after the 120 days over. So when the claimant asks for requested for the returning of vessels, why the point of free time of 120 days came? But there is no provision that you have to complain or make any request between 120 days.
Because counsel understand this that the claimant did not pay anything, and that is why actually the argument came in the first place. If the claimant had paid, the scenario would have been different, most definitely.
So any request or complaint can be made after that, after 120 days, according to your statement.
Yes.
Okay, so did you are saying that the payment is due. Did you send any notice or letter to the claimant about the due payment?
Yes, we did.
On which date?
We have sent the notice, but we actually did not get any response from the claimant.
On which date you sent the letter to the claimant? Okay.
After the 120 days trial period was over.
Okay, after 120 days over, you send the letter. So the agreement states that in clause 10D that the charter have empowers to withdraw the vessels if the payment from the claimant side is due beyond a period of 7 working days. So after so the payment is due from 2017, and still after 2 years the payment is due, and you didn't you just sent a letter just during these 2 years. You just sent a letter. Why didn't you take any other step to take the payment from the claimant? Or do you have take any other step to take the payment from the claimant?
Counsel, understand this. The question in the first place actually didn't much make sense, because if the notice sent in due date, if the claimant does not reply to the notice in the first place, the best that respondent could do is to email them and or send someone to approach the claimant in the first place. But if they do not have any tendency to accept the notice at all, it is pretty much obvious that if the notice was sent via electronic way of sending notices or any other ways, the claimant would not have replied at all. So considering that, the respondent did not send any other ways.
But that is not in the fact that you have sent the letter, or you don't know the exact date on which date you send the letter in electronic media, through electronic media. Okay, moving to the next question. Did you get the notice from the claimant about the termination of the contract?
Could the council repeat?
Did you get the notice of termination of the contract from the claimant?
No, we did not give any.
But in your written response, you clarified that you prefer to keep silent because after 28 days, the contract will be terminated. And according to your statement, you didn't get the termination, the contract of termination letter of the contract from the claimant side. So it's a little bit contradictory.
Council, could you refresh one more time, because
About my last question?
yes.
Did you get the termination letter from the complaint from our side?
From the claimant?
Yes, from the claimant.
No, we didn't.
You didn't get any letter. That's why I'm saying that you, in your written response, you say that there is no necessary to answer the notice. That means you accepted the notice, but you prefer to stay keep silent because the contract will be terminated in 28 days. Okay, thank you so much. No more questions, Honorable Arbitrator.
Respondents Counsel, would you like to do a redirect examination of your witness? Respondents Counsel? I understand there is no redirect.
Sir,
Sorry,
Yes.
Mr. Arbitrator.
Yeah, go ahead, please.
Yes, we have no questions. We do not have any questions for redirect cross-examination, redirect examination.
Okay, thank you. So that means we can proceed to the closing argument submissions. I may now invite Claimant's Counsel to please submit your closing submissions.
Thank you, Honorable Arbitrator. Honorable Arbitrator, we would like to start our closing argument by a quote made by the first counsel of the respondent side. She said, and I quote, "They came to us, they signed the agreement. But Honorable Arbitrator, we both signed the contract and we both have rights and obligations under this contract. It was not a contract of servitude where one party was the master and another party was the servant. So they can't escape from their liability. Honorable Arbitrator, the respondent side has not only misinterpreted the provisions of this agreement, but they has also distorted the facts, and in places they have even contradicted themselves. So we will start our closing statement with a rebuttal of their position. Firstly, Honorable Arbitrator, the respondent has stated in their response that any request for change of route should have been made within 120 days of the free time. But this is a total misinterpretation, since the free time was only concerned with the payment of the charter hire. The agreement clearly states that the free period is for promotion, that they also have said, and preparation of the business, not for complaints and requests. So their position that we have to make any complaint or request within this 120 days period is totally false. And if such was the case, the rider clause number 22 would not have provided for the modification of the agreement beyond this period. Honorable arbitrator, they have also mentioned about their dues, but they never took any step for the realization of the dues. They state that they have sent us a notice, but they have failed to answer which was the date of the notice, because we have not received any notice. They once they say they have sent us a post, once they say they sent us an email. What was that actually? Was it a post or was it an email? What was the date? Because we have never received any sort of notice or email from their side. So this is a total lie, honorable arbitrator. Secondly, the respondent are contending that any request for return of vessels should have been made within 120 days that I've already covered. And we are also contending that, as stated, this was not what free time was intended for in the agreement by the parties. Besides, they have also stated in their response that any of the claimants' deliberation regarding the vessel's faults should have been made within this 120 days. But honorable arbitrator, we have never said there was any fault in the vessels. We have never complained about the conditions of the vessels. Our complaint was regarding the routes. Therefore, this position by them was misleading. Furthermore, the respondent has asked us to check whether the notice sent by us was in correct form or not. Honorable arbitrator, it only shows that they are not aware of the content of the notice. In our response, we have stated the exact dates when we have sent the notice, and they have further resorted to lies. They are saying they have not received our letter regarding the termination of the contract, while it clearly states here that received by the office of the respondent on 22 April 2019. I repeat again, honorable arbitrator, the office of the respondent has received the letter of the termination on 22 April 2019, but their witness has stated that they have not received any source of notice. Thirdly, they even contend that there was no obligation upon them to respond to our letters. This statement only proves our contention that the Port Authority has been grossly violating the covenant of good faith. What they have termed as unprofessional behavior is what is referred in legal terms as absence of due care and attention. That is, want of good faith. Finally, their position that the agreement is not terminable only in case of war and emergency is also flawed. Honorable arbitrator, in clause number 20, there is a statement that both the parties can terminate the contract on their own wills with a notice of 28 days. It only shows war and emergency were not the only situation that was contemplated under this agreement. The claimant, we believe that as per the requirement of the agreement, as well as the section 39 of the Contract Act, we are within our rights to terminate the contract. And in the leading case of Tower Hamlets versus British Gas Corporation, it has been said that a notice can operate as a termination of the contract if such notice have been made under the requirements of the agreement. And as we have stated again and again, that they have received the letter of termination of the contract on 22 April 2019. Honorable arbitrator, we have reproduced every day when a letter was sent by us, but they have not been able to show any of the dates where they have made any sort of a request or any sort of reply to the letters. They are contradicting themselves. Once they are saying that they have sent us a post, once they are saying they have sent us an email. But as they are saying that the dues have not been recovered, they have not taken any position for the recovery of the dues. They could have taken back the delivery of the vessels if there was a due, but they have not done anything. A question remains, honorable arbitrator, about the redelivery of the vessels. An important aspect of this dispute, honorable arbitrator, is that the respondent, Port Authority, is a statutory body. They have obligation to manage the port and other matters connected to it within the responsibility of due diligence. The vessels that have been subject to this agreement are procured from taxpayers' money, but the respondents have no headache whatsoever regarding the whereabouts of these vessels, their conditions, or their redelivery. Port authorities' actions, or rather, if I may say, the omissions, are surely in violation of various provisions regarding their statutory responsibilities. Although those are not subject to this tribunal's jurisdiction, so we would not talk about their statutory responsibilities. But however, under this agreement, the respondent do have the obligation to take back the vessels, and we are contending that the contract is terminated. Honorable Arbitrator, to sum up, we have proven that there was a violation of the bareboat agreement, that there has been a violation of good faith from the respondent's side. We are contending that their inactions and actions have led to financial damages, losses on our side. We also contend that the agreement stands terminated. So the two things that remains to be answered is the redelivery, that we are saying that they are bound to take the redelivery since it's their property and we have terminated the contract. And lastly is the matter of compensation. We are claiming twofold compensation. Firstly, because of the expenses that have been incurred because their inability to respond to our letters. And secondly, a special damage due to their violation of the good faith. And if I may quote from Hadley versus Baxendale, where two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such breach of contract should be such as may fairly and reasonably be considered either arising naturally according to the usual course of things from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both the parties at time they made the contract. Honorable Arbitrator, we raised our case saying that in this dispute, one of the parties has been doing all their obligations, abiding by all their obligations with due care, attention, and honesty. And the other party, they seem to have even forgotten the existence of this agreement. So the party which have been diligent, which have been honest in doing their obligations should not be punished. Rather, they should be compensated for all the losses that has been incurred due to the omissions and actions of the respondent side. If Honorable Arbitrator do not have any queries, I would like to rest my case.
Thank you, Counsel. May I now request Respondents' Counsel to submit their closing arguments?
Yes, Mr. Arbitrator. I, Nazrana Khan, am here for the closing statement. First of all, I would like to mention that the Claimants Council, Honorable Claimants Council, just point out that they gave us notices and they wanted for the change of routes. First of all, I would like to mention that they missed the trial of 120 days, which is very unusual to give such time to some company for just a trial basis. And that trial based time was totally free. For like 4 months, they used the vessels totally free, and they were obliged to give after 120 days the full payment. And they were also obliged to give the advance 30 days payment of 45 lakhs, which they didn't. And they didn't even bother to mention that payment because they're proving that they don't have to pay that advance at all, and which is a proof of their negligence to the agreement and to their company as well. And then they had 30 days to give a notice, which also they exploited, because if they had any notice, if they had unprofitable, if they had any loss from the vessels we rented them, they could have known that in the first month, in the routes they're using the vessels, the unprofitable situation can occur in the first month or second month or third month. And we gave them total 4 months, 120 days, and 30 days also for a notice time. And they expired 5 total months for the notice and for payment. They didn't even get us the advance payment, and then they give us a notice on 16th July 2018 to return our 2 vessels, which is very unprofessional and very improper, that they didn't even care our agreement, didn't even noticed our agreement, and they just wanted it like their way. And when they wanted to change the route, it was 26 July 2018, which is 17 months and 23 days late. And they didn't even pay a penny, and they expected from us to accept their request and accept their unprofessional request to the coastal areas, which also our which is also not applicable by our clauses of the agreement. They are proving that in every step of our agreements, they are unfollowing the rules there, which they signed happily, knowingly, because they are very well known, and which is mentioned here, that engaged in the business of maritime and other related industry with a high degree of goodwill and reputation, represented by its managing director, Mr. Javed Rizvi. Then why would they do that? Why would they do such a irresponsible work with the agreements? And they knew that we won't accept their request. That's why they requested the notice. They sent the notice after 5 months, after 17 and 23 days, 17 months and 23 days, and they wanted to terminate the agreement, which is a breach of contract, I would like to mention, because that agreement will terminate after 5 years. And if they want to terminate, they have to pay the full bill, but they can't terminate in the middle of the contract, which is very unprofitable and unprofessional for us as well, for the government company as we representing. And that is why we would like to claim our claims, that we would like to have our full bill with 12% interest, which is mentioned in clause 22, rate of interest payable to owner 12% if any delay in payment of hire will be applicable after 60 days. After 60 days, they have to pay full payment with 12% interest, and it won't be applicable the coastal routes request, because it is not our bylaws, and it is not very profitable for us, for our vessels, which may occur if we accept the request, which may occur the vessels with grave danger in the coastal areas, and we don't know what actually they want to do with the coastal routes, because they really didn't mention any portal address about the coastal areas. And we know that in international water, it can happen anything, and we can't have that danger in our vessels, to our company. And that is why we would like to have our full payment with the agreement totally not terminated, and which is going on, and we will have the agreement after 5 years terminated. And if they want that the if they want us from suing, why we didn't sue them, why didn't we take any action? We noticed them various times and they didn't respond to the notices, and which day notice got there and which notice we send them. It is very specific that after 120 days we send them various notices and they didn't respond, and even they told that they didn't get any notice, and that is not that honesty they're showing. So we'd like to have our contract agreement in our place, which we have, and we will sue them if they don't get us our money back, and if they don't pay them with 12% interest. And we didn't sue them because they are well-known company. As I said before, we are well-known company and they are also well-known company, and we didn't want to stake on our reputation on stake, and didn't want to break some agreement with the dishonesty of them, and that is why we didn't sue at the time. But if they don't pay our bills totally with interest, and if they don't follow our rules, follow our agreements on which we both signed, then we claim to you, Mr. Arbitrator. That's all, Mr. Arbitrator. That's all I have to say. Thank you.
Thank you, Counsel. With that, we can formally conclude the proceedings here, and I will pass the floor back to Ms. Rana.
Dear all, it will take 5 to 7 minutes to prepare our result. During this period, we will watch a video on introducing BIAC. Dear all, we need few more times to announce our result. We can take a short break for 5 minutes. Please do not sign out from the session, but you can keep the video and audio turn off. Now, I would like to request our chairman of the session to declare today's result.
Thank you, Ms. Runa. Before announcers, I'd like to congratulate all the participants for doing a fantastic job. I think all of you did pretty good. I understand it can be nerve-wracking. It may be the first time for some of you to participate in this competition. Some looked experienced, but overall, I think there was no lack of effort as far as all the participants are concerned. So congratulations and well done. I know this must be difficult. You must be running out of patience. But yeah, so to me, as I said, overall, most people did fine. But to me, the winner was the claimants team. And I'll give general reasons. I won't single anybody out, but I will single one person out for being sort of the star of the team. And that's if I'm correctly pronouncing the name, Ariful, the first counsel who did the closing submission as well. Is that the correct name? Arafat, right? Yes. So I think you were excellent. You did a very good job. And of course, see, one of the things as an arbitrator, as a judge, that you look for is, of course, persuasive arguments. As lawyers, you know that's pretty standard. That's pretty normal to expect. But I think one of the other things is what we need to see is a bit of emotion. By emotion, I don't mean you have to engage in theatrics and melodramatic conduct. I read a book once in which it was by a Supreme Court justice who said that although we are supposed to, as lawyers, appeal to the sense of justice of a judge, we're also supposed to appeal to the sense of emotions. And by that, I mean that you have to make your arguments interesting. Especially in this digital age when you're doing everything online for the most part, there is no in-person appearance, there's no in-person interaction. So all the more reason for you to actually bring that emotion to the table. The arbitrator should be convinced that you actually believe in what you're arguing. As lawyers, you need to be dispassionate, disconnected with the case, but at the same time, you need to show some passion, some emotion as far as your arguments are concerned. Right? That doesn't mean you don't use logic and the law and all that. And of course, you cannot win a case without that. But as an auditor, as somebody who's presenting the case, I think that is important as well. I think that was lacking in most of the speakers, unfortunately. But I think I saw that in Arafat. So good job. And I also liked how Arafat was citing a lot of case laws, which I thought was missing in most of the other counsel. End of the day, you could be very articulate, you could be very eloquent speaker, but if you cannot submit or substantiate your arguments with the laws, you cannot win the case. The arbitrator, the judge might think you're a very charismatic speaker, you're a great speaker, but if you have not relied on any laws to substantiate arguments, how will the arbitrator judge decide in your favor? End of the day, when we have to write an award or a judgment, we rely on laws. And your job in a court, of course, as an officer of the court, and then, of course, a representative of your client, is to actually facilitate that, to help out the judge or the arbitrator decide the case in your favor. The judge might like you, they might think you're an honest person, you have integrity, but if there's deficiency in terms of legal arguments, you cannot win the case. The same goes for emotions and passion as well. You could be very emotional, very articulate. That could be very impressive. End of the day, if there is no legal argument, you can't win. So be mindful of that as well. Be also always prepared for questions. End of the day, as lawyers, we like to give our long presentations. We don't like being interrupted. I think that's true for a lot of humans in general, not just lawyers. But you should always be prepared for any types of questions. Of course, the judge, arbitrator, because they have a certain mind, they're applying their mind while listening to you. Some of the issues that you think are relevant may not be relevant to them. So be prepared about that. Just because that issue is very important to you, the argument is very important to you, the judge or arbitrator might not think much of it. So be prepared for any kinds of question, and of course, address those questions, answer those questions. If you cannot answer them, you can always let the arbitrator know, I'll come back to you, although we usually don't like that. We need answers right away. So if you cannot answer, don't just waste time, say, I cannot answer that at this point, but I will try to answer this during the course of the proceedings. That's important. Body language is key also, especially in a Zoom setting. There's a trade-off. Of course, you cannot see the full body. Of course, some lawyers actually like that. They like going up to the podium, and with their body language, they try to be more compelling. But you have that constraint here in Zoom. But at the same time, you have your face, which doesn't mean you have to be very expressive in terms of your face, but that's the only thing we focus on. So we need to see sort of professional body language. You shouldn't be too uptight, too stiff. You can be a bit more flexible as well, but at the same time, not too dramatic, as I said earlier. Also, I think teamwork, of course, is key. And I think that at times there seemed like there was some confusion in terms of who's going to do what. So of course that needs to be coordinated. That's a given. Other than that, I think that is pretty much it. So of course I'd be happy to answer any questions you have, but overall, well done, congratulations, and good luck.
Congratulations to the team of Chittagong University, and thank you to the team of Independent University Bangladesh. I would like to request all participants and our chairman to turn on their video for capturing a photograph. I would like to conclude the session by thanking the chairman of today's session, Mr. Rana Sajjad, and the team members of the both universities, along with their faculty members who worked hard to train up and prepare their students for this contest. Before concluding, I would like to invite you all to our semi-final session to be held on 26th November. Thank you all for joining us online. Allah Hafiz.
Allah Hafiz. Thank you once again. All the best.
Thank you. Thank you, Mr. Sajjad. Thank you so much. We'll be in touch.
Thank you. Take care. Bye-bye.